Good afternoon. Welcome to this afternoon's webinar on risk management. This is Victoria Beal with the Ohio LTAP Center, and I'll be turning things over to our presenters very shortly. I would just like to go over a couple of quick housekeeping items. First of all, I'd like for everyone to please look for the question box in your GoToWebinar panel. And if you would please drop me a hi, hello, good afternoon, good morning if you're still somewhere over on the west side of the country. Just so I know that you found it, I would appreciate it. This is the box where we'll be taking questions today while the presenters are doing their presentation. We will also be unmuting the audio for you to ask audio questions throughout the presentation today. That worked really well with this series last week, and we're hoping that you'll be engaged enough to want to unmute and ask verbal questions as well. So with that, I have some hellos or highs coming in. Glad you found the question box. There are a couple of handouts for you in the handout section of the GoToWebinar panel. One is a copy of today's slides, and the other is a copy of our Ohio LTAP e-learning catalog. The slides and the catalog will be emailed out to you after the webinar completes in case you have any issues downloading them. But we wanted to make sure you had the resources. And also specifically, once the webinar completes, take a look at that Ohio LTAP e-learning catalog. It provides you over 200 different courses that you can complete on your own time and at no cost, all related to transportation matters and work that you or your staff do on a daily basis on Ohio's transportation system. So with that, I'm going to turn things over to Jared. Jared, are you ready?
I'm ready to go. Thank you very much, Victoria. I appreciate it. So I'm Jared Turner with TBT Construction. We're a design build commercial contractor based out of Cleveland, Ohio. Sitting next to me is Sam. We have a small technical thing going on where both of our names show up as me today. But this is Sam Thomas next to me, and we'd like to talk to you guys a little bit about risk management and how it relates to what you guys do and contracting with ODOT, government agencies, and also with general contractors and just contracting in general. At any point, if there's any questions or anything you guys want us to expand upon, please go ahead and throw something into that text box, send us a question, and we'd love to make this as interactive as possible and get you guys involved and share some of your stories as well. So for today's agenda, we're going to be going through first elements of a contract. We're going to go through some construction contracts specifically, just go through a few of the key points related to that. We'll talk a little bit about change orders and some things to watch out for. Going into legislation and agencies. We'll talk a little bit about Ohio mechanics lien laws. And finally, we'll wrap up with a few of the ODOT standard contracts and documents. So with that, I'd like to go ahead and hand it off to Sam Thomas over here.
Good afternoon, if it's that time where you are, or if it's morning, good morning to you. Garrett and I did this about 2 years ago, was it, Jared? And we had a lot of fun. But in the midst of that, we think we did a lot of disseminated a lot of good information that the participants could take back into their work setting to help make a difference in their operation. And the difference that we're looking to help you make, and a positive difference, and that is risk management. When you think about risk that you might encounter, some of the risk is predictable, then there's some that's unforeseen, but there are some ways to deal with it. What has qualified me to be a presenter here today and to talk and share something that might be of value to you is the fact that I've practiced law for 25 years as a sole practitioner in that period of time, which means that I didn't have the luxury of putting off certain areas of law onto somebody else in the firm. I pretty much handled and continue to handle all areas of law that come into the firm. Lately, though, I've been spending more time with contract law as it relates to business owners, contractors, and owners themselves, whether they are homeowners or owners of businesses that contract with contractors to do work for them. So it's given me some pretty good hands-on experience. So when I speak, I want to be able to also just talk about, some things that have come up in my practice. And just like Jared said, he encourages you to go to the text box and give us some feedback, because what we're going to talk about is we're going to talk about contracts. And contracts are pretty generic in terms of them being, what makes up a contract, the elements of a contract. And those elements do not change no matter what industry that you're in. But your feedback and your comments and your questions might give us an opportunity to steer some of our feedback that's more germane to what your situation is. The first slide is the elements of a contract.
Right. Before we get too far, we also, we're ready for poll question number 1 if you are, Victoria.
Okay, I'll put that up. All right. Why are contracts needed? I'll put that poll question out there. And you have options of manage risk, list terms of contract, allocate responsibilities, identify parties, or all of the above. And they are voting quickly, and they seem like they're a very bright group, because I'm guessing that they're getting this answer right. Okay, we're over 70% voted, so I'm going to close the poll out. And I'm going to share your results, which are 100% voted for all of the above.
Excellent.
Oh.
So you guys might be preaching to the choir here. We'll see.
So,
All right, all yours.
okay, very good. So when we talk about the elements of what makes a contract, the reason that this is important is that if some of these elements are missing, then it puts in question the enforceability of the contract. So we want to make sure that we get all of the elements of the contract listed in the contract, and that the parties are eligible to participate in the contract. So the first element is an offer. In the context I want to talk about an offer is if you are planning to do business with the Ohio Department of Transportation, the way the system works is that the department might put out an invitation for you to submit a bid. Well, that invitation and your response with the bid becomes the offer for the Ohio Department of Transportation to accept the bid or not to accept the bid. And you would, there would be procedures as to how that acceptance takes place. And if the bid is inclusive, it has all the terms of what makes the terms of the contract understandable, and it creates the opportunity for mutual agreement, which is really important between the parties. That if you send out a bid and it doesn't have, who the parties are, what the scope of service is going to be, what the remuneration that you're looking for, etc., well, then the department won't know whether or not that is a bid that they want to accept. And that takes us to the next element, and that's the acceptance. ODOT can accept or reject. And formally, they can send back a letter or an email accepting it or not accepting it. But if they do, then there's mutual assent, which is a requirement of a contract. Next is consideration. In your bid, you're going to have exactly what you're going to be offering, what project, what product, what property you're going to be offering, if you're going to be offering protective services in exchange for a certain amount of dollars that the department will be paying. There might be an occasion where the department or whomever, the person that would be considering your offer to do a counter offer in terms of price, in terms of products or whatever. And that counter offer, if it's made, that null and voids the original offer that you made. So you start out with a new contract altogether. But again, we want to look at whether or not both parties accept in the final analysis, what the final contract is. Just some commentary. You might hear me talk about, there are different rules for what makes a contract enforceable or not, and that's the key term. And those rules, for every rule, there is an exception, and we'll talk about that later. So who has the capacity to enter into a contract? Well, in the state of Ohio, you have to be the age of 18, and you have to be mentally competent. So let's just talk about age at this point. If a person is 18, then that gives them the capacity, at least age-wise, in order to engage into a contract. Now, remember I said that the law is full of exceptions to the rule. That's the 18-year rule. But if a minor is contracting for a necessity like food, shelter, or something that's necessitated, well then that is an exception that that is satisfied, and the person might be considered having the capacity to enter into the contract. Mental capacity that's another element, and it's very important that you engaging with people that are mentally competent. I'm dealing with the situation now where family members are saying that a family member of theirs was taken advantage of because they believe that that person is mentally incompetent. But they have to prove that by a psychiatrist or someone that the person is incompetent. But again, these are elements that are very important in order to be able to prove to make a contract enforceable. Then, of course, it goes without saying that the contract needs to be legal, no illegal products or services, gambling, drug dealing. Well, the government and the laws are not going to enforce illegal contracts. Next is the statute of frauds requirement. That certain contracts must be in writing. And we want to be wary of this because you might, have all the terms there, and but you don't understand that goods that are priced over $500, that must be a part of the contract in order to make that enforceable. Contracts lasting more than a year must be in writing. All land contracts, sale of real estate, must be in writing. And if you contract to pay someone else's debt, well then that must be in writing. Maybe this will help you understand a little bit more about the requirement of it must be in writing if it's a year old. Rental contracts, for instance, usually the first year is in writing. It must be in writing. But if the person doesn't sign for subsequent years, then it goes month to month. Well, by it being month to month, that doesn't require a writing. The seventh element that we want to talk about is the statute of limitations. You might have a contract and somebody might breach that contract. If it's an oil contract and it's enforceable, well, you must enforce that breach within 4 years. If you don't, then the statute of limitation runs and you don't have any recourse. If it's written, it's 6 years in order to enforce it. And again, if it's a written for sale of goods, it's 4 years.
Okay, and then I'm going to jump back into construction contracts a little bit. With that, we can go ahead and ask poll question number 2, please.
It's launched. Second poll question is, do you use standardized contracts? And our participants can select from yes, often, not often, or never. And they're voting quickly again. It's nice to have an audience that's so engaged in the topic.
Right.
All right, we're over 70% voted, so I'm going to close this down and give you the results. We have 29% that said yes, 53% that said often, 18% that said not often, and no one voted for never. So I've hidden those results and it's all yours again.
So with that, I just kind of wanted to touch base on construction contracts. As Sam said, it can be even a verbal contract. For me, when I kind of do unofficial, not quite standardized contracts, for us, it's just our standard 2-page proposal form. So essentially, it's a really brief outline and summation of what our agreed scope of work is. For our industry, it's metal buildings. So I usually would have, a date of the proposal. I have the scope of work and what kind of metal panel we're putting on the wall panel, what kind of framing is going in, what kind of roof the building is going to have. Then it gets down into payment terms and kind of standardized general condition kind of things. But all of that can be on a simple, small 2-page document that has my signature and my customer's signature on it. Depending on if it's a larger project or a smaller project, we don't always use a full schedule of values and a full 15 line item contract like a standard AIA standardized template would be. So for a lot of construction contracts, when you guys are getting into the standardized contracts, it's really a better way to do things as far as any sort of a major project. And honestly, I've had some of our general contractors, it's almost every project, even if it's a small overhead door or a hollow metal door or something going into a building, we still have a roughly 15-page contract to go through to make sure that all the I's are dotted and T's are crossed, so to speak. So general contracts usually have 14 or 15 sections going through general provisions and general conditions is always the first thing. And then the next few line items are kind of just defining key players, who's the owner, who's the general contractor, who's the architect of record that would help with clarifications, how subcontractors are handled, and if they're already determined on the project. Is the construction by the owner or by a sort of a third-party agency that's a owner's representative? Number 7, going over change orders and how you want to handle that. A lot of times that's predetermined in the contracts. The time and duration of the project, how payments are handled, payments and completion, and that can kind of relate to schedule as well. Is there any retainage going to be held on the project? A lot of projects have either a 5 or 10% retainage that's held out by the owner until the project is complete. Protection of persons and property, that has to do with the insurance sections. Sometimes they have different insurance liabilities that have to be adjusted. We just had a project where my personal policy had to go from a $1 million umbrella policy to a $2 million umbrella policy for one of these particular projects we were working on. Insurance and bonds related with that. Uncovering and correction of work, that's not in every contract, but that's just how to deal with when you come up with change order related things. Miscellaneous provisions. Termination or suspension of the contract if something is not happening. That's how the owners and or owners representatives have the authority to change things and end the contract, and claims and disputes. Really going for a subcontractor to contractor relationship, it's almost an identical kind of format. You essentially just have to make sure that all the parties are clearly identified and everybody has everybody's correct and up-to-date contact information. And really you just kind of go from there. So anybody have any questions or anything that anybody wants to talk about specifically about any contracts or any contracts that they're dealing with or anything along those lines?
There's no raised hands and no questions in the question box right now.
So from that, we can kind of jump into change orders. And with change orders, we can get into poll question number 3 as well.
Sounds good. I'll get that question launched right now. So the question is, have you ever been burned by a change order or lack thereof? Yes, no, not yet, currently ongoing. Folks are voting quickly. We're getting a good diversity of votes too. All right, looks like the majority of people have voted, so I'm going to close this out and share the results. 58% have said yes, 26% said no, 11% said not yet, and 5% said currently ongoing. So I'll hide that and it's back to you, Jared.
All right, so I can share one of my personal stories, but this is one where I'd like to, without getting into too much personal information or, sharing anybody's specific names, anything like that. Does anybody want to share any change order issues that you guys are dealing with that are either currently ongoing or recently closed out and how it worked out for you?
And you can raise your hand if you'd like me to unmute you, or you can drop something in the question box. This is almost like change order therapy. Just kind of talk it out.
While we're waiting for anybody to respond, if they're willing to, I can go into one that it wasn't actually a change order. It was just a little bit of a lack thereof situation. We just had a officer meeting Monday. I've got 2 brothers that work with me in my company. And one of our clients, we had a verbal change order for a overhead door project. We're installing overhead doors into an existing facility. The customer requested a change to the trim condition on how the overhead door trim will go around on the metal siding to the door jamb condition. Instead of doing a wrap is what the customer would want. Our standard is just to put a simple angle iron, simple transition, and our verbal agreement way back when was that the customer was going to paint the door jambs. That changed to a custom trim that's supposed to wrap the entire roughly 8-inch overhead door header, if you picture like your residential style overhead doors. And when you have that much metal going across on a trim piece, it's only a thin piece of sheet metal. There's oil canning and some distortion in it and whatnot. So we're running into an issue right now where we made a change per the customer's request. Now that change worked out poorly, kind of as we thought it would in the beginning. And now we're at the end of the project trying to get our remaining 50% of the contract paid for, and he's holding workmanship over our head on a change that was kind of self-inflicted by his wishes. So we're still in process with that one. We're planning on installing some additional trims to make it look much better and clean things up. But that's still just additional work and some other things that we had that were kind of unforeseen on our part. So that's kind of my story to go along with it. Anybody else have anything they want to share?
Well, nobody wants to share yet, but I would say we come back to it.
That's fair. We'll have time at the end to kind of go over anything that anybody might want to talk about. So what is a change order? A change order is any change to an original contract between two parties. Can be related to the scope, can be related to price or schedule. It's not a separate contract. It's not always a cost adder. Sometimes I've had projects that things have happened faster than I expected them to, and we were able to discount projects, and we can, pull back money out of things. It can also just be related to schedule, where it's just a timing thing with crew availability and things like that. I'm sure some of us might have come up with some issues related to scheduling this past year with COVID and all the craziness that we've had for about the past year and a half here. So what are common reasons for change orders? A lot of it's going to have to do with design changes or things that are just a little bit different in the field than you expect them to be when you're looking at the architectural drawings and see what things are looking like when you get out there into the real world. Plan modifications or deletions, or just scope that it's been revised as the project kind of grows and matures. Any extra work or a reduction in work that's required for the original scope. Any new instructions by the owner, architect, or a general contractor or superintendent. For me, I've even had it with trash cleanup and just helping a general contractor out that just requests, whether it's a forklift that we have under our sort of subcontract deal, or when anybody needs a little bit of extra work done. Sometimes we have an hourly time and material change order that's associated with that. If drawings on the architectural side are unclear or need to be more detailed, if the materials or workers are delayed like we talked about, site conditions are not as expected. For us putting up buildings, I'm sure road construction is kind of similar. When you get out to a site, sometimes you're dealing with the rainy springtime season that we've had for the past few weeks here, and everything's muddy. They don't have good stone brought in to bring up the compaction, and it's just a lot more difficult to work in that area. That could be a potential discussion for a change order. Any safety issues or unforeseen issues related to that. A poorly defined scope of work, unrealistic timelines that are in place. We've also had projects where just timeline expectations are just not realistic for the scope of work that needs to be completed, whether for us it's steel erection or any of your guys' industries. And then the same thing with the budgets. So with change orders, you always want to start with a contract. There's no such thing as a perfect contract. I mean, there might be a very simple one, but I haven't seen very many. You want to start early and save by negotiating with the original contract before you actually sign off on everything. As you're reading through these 15 line items on the contract, if there's things that you guys don't agree with as a subcontractor, now's the time you can go ahead and send that with red lines and your notes on it, and your initials and timestamp it. You can send that back to the issuing entity, whether it's a general contractor or ODOT directly, depending on who you're contracting with. But don't be afraid to really redline and mark up that original contract. A lot of the general contractors out there are really good at covering themselves, and sometimes these things can be a little bit lopsided, where you feel like as a subcontractor you're a little bit more at risk than the general is that's issuing this contract to you. A lot of them, not pointing any fingers, but there's a lot of cut and paste issues in some of these contracts. A lot of that I've kind of run into the same thing, even with my 2-page little proposals sometimes, that I use a standardized template or a past project that was kind of similar, and I don't catch a couple of lines in there that I have to double, triple check my quantities and make sure that everything lines up and makes sense and is pursuant to the project at hand. And then of course, it is the change or the change order that you're talking about. Is there a provision somewhere in the original contract documents that explains how to handle that? Like you might already have a a dollar amount that's agreed on for an hourly rate or something related to that. So the change order process is typically, especially in the larger contracts, there's a line item section that specifies the procedure and how you proceed with that. And a lot of times there will be standardized documents and everything that are provided from the general contractor or the owner. It's typically in the general conditions section. A signature is always highly recommended. There are verbal change orders, but that's always at your own risk. You might run into an issue just like I'm in, where I'm not quite sure about whether or not we're going to get paid for the additional work, but it's a small enough dollar amount that I'm okay just to incur that cost. It's not always the case. You want to make sure that the change order was directed by somebody that has the authority to do so. And what Sam was talking about, that person has to have the capacity to do so. So you can't have a change order that's been authorized by, this might be an extreme example, but like a laborer on site or somebody that's not a foreman or that doesn't have the authority to make any financial decisions regarding the project. That can get you into trouble. So was there an existing agreement on scope, budget, or timeline that's in the contract that should be adhered to, or is there really a reason for the change order? When you get into verbal change orders, you want to always send out a memorandum of understanding email. If there's no response, you kind of have the key phrasing in there that says, if I don't receive a response to this, we consider the above to be accurate and correct as of today's date. Sam can talk about it a little bit later. I'm not sure about text messages and the way that technology is changing and phone calls. I know lawyers always used to want everything faxed. I know that we're getting into emails a little bit more prevalent these days. So we can have Sam touch base on a little bit of the legalities of some of that a little bit later as well.
Okay, good job. Thank you.
I'm still, I don't know if you want to talk about the email or verbal contracts or changes at all.
Well, again, as I was stating earlier, the contract itself dictates the form of communication, whether an acceptance or changes or whatever, what format they should take place, whether it's email, in writing, certified mail, verbal. But I always tell my clients, verbal conversations disappear. We need to have a writing. Again, the contract will spell out what's acceptable and what's not acceptable.
We also have a cardinal change rule. That's essentially if there's a change order that's large enough to completely nullify the original contract. It would be a significant increase in the amount of work that needs to be completed, usually to the tune of double or more. A significant alteration to the type of work that needs to be completed. If we're, for an example, we had one building that we submitted a proposal to put up a 40 by 50 building. When we got out to the site, we learned that little 40-foot by 50-foot building was on a platform that was 30 feet in the air. So that obviously was grounds for a renegotiation of the contract and rechecking everything that has to be done out there at the site. A significant change in costs or the location. If I'm putting up a building in Cleveland and I have a agreed upon price for doing that, that same price or the same size building can't just be transplanted out to Toledo, Ohio, or Cincinnati or Columbus. For me, it's because of code and load issues with snow loads and wind loads, and every single project is extremely unique from that perspective. There's also force account change orders. It's based on actual costs to do the work. It's pretty much just a predetermined unit cost for whatever the scope is that you're working on. For ODOT, they have their own sort of templates for predetermined pricing for everything from temporary traffic cameras to, stone per unit, or, concrete parking blocks or what have you. There's a predetermined price for that with force account. So from a contractor's perspective, that can be great because you're paid the actual cost plus a little bit of markup on it, hopefully, depending on how pricing is going. If pricings are somewhat standard as compared to how they've been for the past year, where everything's been increasing almost exponentially, it seems, on steel and wood and everything that we're seeing these days. And the only bad part about it is that you have to track everything, and you have to make sure that your systems are up in place and your guys in the field are really good about making sure they get you accurate quantities of what's happening out there. And then from there, I can hand this back over to Sam to talk about legislation and agencies.
Do we have any polling questions for that?
Yep.
If so, let's hold off on that for a second. I just want to kind of commend Jarrett for his presentation on those change orders. And if you were listening, you understand how important it is that the formation of contracts is extremely important, because all of the change orders that he's talking about should have been anticipated at the creation and the formation of the contract, because those things can expose the homeowner as well as whoever the owner of the buying the service is. It can expose them to a lot of risk, and at the same time, the contractor can be exposed to a lot of risk as well. I had a business owner contact me yesterday, very frustrated about work that was being done in anticipation of her opening up on the 1st of June. And she was telling me this contractor showed up when he wanted to, wasn't doing the work, and finally, just yesterday, told her he's walking off the job. He's paid in full, but she's got this event coming up on the 1st of June. So now she has to find another contractor, pay them all over again. So the question I asked her was, do you have a contract? And the answer is no. But a contract is not always the panacea to solving and reducing the risk that you might have. Because even with a good contract, as Jarrett indicated, there could be something that would cause the timeline to go askew. And then a provision of the contract says that, the contractor must complete it at a certain time. And if you don't, there's going to be a 5% or whatever percentage decrease in the amount that contract is paid as a result of not meeting that timeline. So you have to anticipate that there could be some things that would cause for that timeline not to be met. And then you want to put that in the terms of the contract, that if X, Y, Z occurs, well, then that waives, this very strict timeline. And again, that's good risk management, so that the homeowner and the contractor are not losing money, time, or whatever. They're self-indemnifying themselves in doing that.
Yeah, a lot of entities out there have liquidated damages and related things to the scheduling. This, for me personally, I'm sure some of you guys are seeing it as well with material lead times and material availability these days, especially this summer and spring and everything going on with COVID. For me, my standard metal building lead time that should be 4 to 6 weeks is more like 4 to 6 months right now. Mm-hmm. And some of these contracts that we see, I haven't had any lately, but we've seen them in the past where they have liquidated damages, and you want to make sure that you redline that stuff and have the conversation about it before you sign off on the contract and send that in to your customers.
Yeah, that's a very good point. But again, getting back to the whole idea of indemnifying yourself, that you should purchase insurance. that covers, these unforeseen and some foreseen reasons for you to be in breach of the contract. I mean, it happens. I mean, look at this pandemic. I mean, it put upon us a lot of conditions that caused a lot of contracts to be breached, very basic contracts. And so if you get the right kind of insurance, whether it's a bond or whether it's contractor's insurance that covers, personal injury to employees or property damage that's caused by your operation, you want to get the right kind of insurance. Again, we're talking about managing your risk. And in the context of contracts, when we talk about managing your risk, that you want to insure and indemnify yourself or that homeowner. For example, if you are an engineer drawing up architectural plans that calls for a certain scope of work to be done, and then the contractor comes on and they do some excavating, and then there's a house next door or 2 doors down that starts to have some structural damage as a result of the heavy duty machinery that's being operated. And then that homeowner two doors down and next door, they will try and sue the homeowner for that. Well, the homeowner should have a conversation with the contractor saying, and the architect saying that you need insurance that if your work causes for this kind of structural damage to occur, you need to indemnify me with that. Well, that indemnification comes in the context of having the right kind of contracts with the insurance company to cover something like that. And I'm not sure of the scope of work that our audience, does. I understand some of you are engineers. I wish I had a better feel for the type of work that you're in. Again, perhaps some of the conversation can be more germane to what you're doing. Again, as Jared offered at the very beginning, put some notes up or raise your hand, ask questions so that we can be very much on point with what your situation is.
And we do have a question for you in the question box. The person said, site conditions not as expected. Is this an issue that the contractor bears some responsibility?
I would say yes, it is. It needs to be anticipated. That's where the engineers will come in, and they should be able to give a risk analysis as to what could be, in the case that I'm talking about, with the woman needing some excavation done on her property and some rebuilding. Well, that excavation caused for a neighbor two doors away to complain that there were cracks in the walls. It did something to her foundation. Well, an engineer will come in and talk about the probability of that and how to manage that risk in terms of the excavation. Do we use, this very heavy equipment in order to do this excavation that would cause for the transference and the shifting of the land that would cause the shifting of the foundation of that house. Again, we're talking about the basics of risk management. And the answer to the question is yes, there is some responsibility, but the important thing is we want to indemnify that homeowner from being sued and realizing a financial loss. And that homeowner should say to the contractor or the architect or whomever, you need to get some insurance that will indemnify and protect me.
I was saying we could potentially unmute you to have a conversation about like what specific issue you're having on one of your projects maybe. Mm-hmm. For me, when we talk about site conditions, it brings to mind really just the past couple of weeks when we're trying to erect a steel building out in a job site somewhere, and we have a certain amount of time in there to try to get wall panel up and try to get that steel up. We can't be working in a complete mud pit, so to speak, right? So we've had change orders in the past related to bringing stone in and, you know, mud mitigation, I guess, for a lack of a better way of putting it.
Yeah.
Just because it's obviously it compromises the project and, you know, crew morale and everything else. And the guys are slopping around in the mud trying to get things done and trying to get a high quality product put out there. It's really challenging to do when the site conditions are subpar. And a lot of times that falls right onto the general contractor if we're a sub, and or it can go right to the owner where you have a conversation and says, hey, in order to mitigate this issue, we're going to have to do something, or we're going to have to potentially have a change order related to the time frame on the project, because you can come back in a few weeks when things dry out, or we can look at a change order to spend the money and bring stone in and do whatever it's going to take to make the site more workable. So I agree with that as well, and it's just it's a matter of making sure you have all the lines of communication open and communicate with all the appropriate parties to make things happen.
You know, we're going to talk about workers' compensation, but I think that what you just said puts it in the context, workers' comp, and also the employer's or the general contractor or even the subcontractor's responsibility to make sure that the risk to their workers and their personal injury as a result of working in unsafe conditions. You know, the Department of Labor, you know, is designed to make sure that work sites are safe. But the point is that going back to insurance, going back to the panacea, if you will, of having risk management in place. If an employee is injured in that mud site that you're talking about by poor management, not coming back, letting it dry and coming back in a week, but just having them work in that unsafe situation, and they encounter an injury, well, then they better have workers' comp. And, you know, the workers' comp, we're going to talk about that a little later, but this is contextual. Any employer with one employee must have workers' comp. You must have workers' comp, and that's the insurance that you have in order to put that worker back, you know, take care of any financial or injury that they may sustain. Okay, I guess we're ready now for the poll questions with our next session.
This question is business entities.
Yes.
Okay. Go ahead and launch it. It's business entities, what are you? Are you a sole proprietorship, a partnership, an LLC, a corporation, or an S Corp? And they're answering quickly. They must not mind afternoon quizzes. Just need a few more to vote and we'll be over 70% and I'll shut it down and share the results. Okay, there we go. I'm going to share our results. We have no one who said they were a sole proprietorship. 6% said they were partnerships. 50% said they were LLCs. 25% were corporations and 19% were S Corps. I'm going to go ahead and hide that and it's back to you.
Okay, very good. So pretty good a distribution, not necessarily equal, but you know, all entities, you know, have different needs, whether it's financial, whether it's ease of formation, or that entity determines, you know, what its priorities are. But a sole proprietorship, it doesn't surprise me that there is very little participation of zero number. because that really defeats the purpose of having an entity, because what an entity does is it provides a limit to the liability of the owner of that particular entity. A sole proprietorship doesn't do that. Now, the pro of sole proprietorship is it doesn't take anything in order to create one. You just go out and you do work. You don't have to register with the Secretary of State or anything of that nature. So it's ease. But the downfall is you are infinitely liable for any liability that proprietorship encounters. Partnership, again, one or two or more people can enter into this. It's ease of formation. One of the liabilities of it, though, is the partners are liable for the debt of the partnership, which is why, as we have evolved, a lot of entities have been created that are called limited liability. And when I look at the numbers, that comprises 50. That's the largest number of people that have LLCs. Again, LLCs are easy to form. There are no strictures in terms of reporting or record keeping, back to the state. So it has all the good features of a corporation, but at the same time, it's easy. Good features including the limited liability stays with the corporation, with the entity itself, the LLC. Corporations are unwieldy, but they have their purpose. When you compare a corporation to an S Corp or C Corp, they can only have a limited number of shareholders, if you will. 100 is the number. Well, what if you have this gigantic project or campaign where you need to raise, hundreds of thousands or hundreds of millions of dollars? Well, those 100 shareholders might not give you the financial power that you need in order to do what you need to do. So the corporation will give you the opportunity to do that. That's the plus. The downside is, again, the formation difficulty, the reporting that you have to do on a yearly basis, and all of the strictures that you must adhere to. Yes.
And then I don't want to interrupt, but
No,
I'm just thinking about my personal example. CBT Construction, my company, is an S Corp. So we're a little bit in the minority compared to an LLC, but I also have like our real estate holding company. We own our own property, and my construction company pays rent to my LLC company that is the essentially real estate holding company that we pay rent to, and they have the property and the building and everything is in that separate entity's name as an LLC, and it's goes back to that sort of isolation and I don't know, a buffer or bumper, anything you can do to sort of isolate the companies and isolate yourself from the risk that would be inherent with your company or corporation.
Yeah, and again, if you look at it in its purest sense, the entity in the state is the Secretary of State that gives the authority through contracts to agencies to develop in any one of these 5 different areas. As you talk about different, you have an entity and then it has different organizations or subcomponents to it. Well, those different subcomponents, they will have contractual agreements, with the parent company as to what their role is. And it's really important, when you have something like that, is to have operating agreements, that tells the subparts, what their role is and what their liability is, and is not relative to the mission of the organization, or the main mother, if you will, of the organization. So operating agreements are very important. And I don't think people understand that and utilize them enough. So I think we've talked about the business entities. And let me just remind people, my name is Sam Thomas, and I noticed up on the screen it might have Jared's name by both of them, both pictures, but I'm Sam Thomas. I'm the one that's talking now. Okay. Again, we kind of interwove the conversation about Ohio Bureau of Workers' Compensation into an earlier conversation, that Jared was having about, working in the trenches, if you will, and how important it is for contractors, employers, to have workers' compensation. And then this shows basically who's accountable for having workers' comp in place. You can see that independent contractors are not eligible for workers' comp. And then there's a form. All of these forms and posters, that we're going to talk about in a second, are on the website of the Bureau of Workers' Comp. Self-employed individual may purchase a policy if they want. There are some kinds of employers that are not required, even though they might have one employee. If that employee is making less than $160 per quarter, they're not required to have workers' comp. And when I say that, I think of some work such as gardeners, housekeepers. They might not, make the magic number of $160 a quarter in order to obligate that employer to be required to take on workers' compensation. These are.
I was going to say, I just kind of threw up our BWC certificate. Obviously, as you talked about, it's a required posting. Every 6 months or so, we renew everything, get all of our hours put in for that bill, and get that sent in, and have this posted up in our wall. It's got to be in a conspicuous area at your office, or potentially even in the job site trailers if you guys are GCing things, or if you're a prime contractor. But I just wanted to share that.
Yeah, that's good. There are other posters that are required, and all of these are enforced by the Department of Labor. And as Jared and I were talking earlier, what is the occasion that would cause someone from the Department of Labor to come out? Most of them are scheduled, by that contractor or that company that wants to make sure that the risks are managed, because they'll come out and they'll review the sites for worker safety, among other things. But another part is to make sure that you do have the postings up, whether it's workers' comp or OSHA or FMLA or EEOC postings. Those all need to be up. The next slide, we don't have a polling question on this, do we?
No, not yet.
Okay, no problem. The DavisBacon Act, as you can see from the bullet points on the slide, its prevailing wage is the operative term. And being a lawyer, one of the things that we try to look at is, what was the legislative intent of acts, that are passed. And the legislative intent of the DavisBacon Act being promulgated back in 1931 was to protect people like maybe our audience. You might not be in a union where you're protected by the union, and by virtue of the power of the union, you can get all the contracts. Well, what this act did was to create a prevailing wage that anybody that obtained a government contract had to pay to engineers or other skilled laborers in order to qualify for their bid to be qualified to be funded by that agency. For instance, CMHA here, the Housing Authority, they have a lot of projects that are worth more than $2,000, and individuals bid on them. Well, what would happen was that the unions would bid, and they would undercut the independent contractors, and they would get all the bids because because of economies of scale, they could bid less than the independent contractor. So what this does is it requires a prevailing wage so that the union could not undercut those independent contractors. Now, I got stories I can tell about how either a union or an independent contractor can get in trouble by putting out bids in order to gain that particular contract. They might not charge enough money, and one clear way that they can make up for that difference is not to pay their employees the prevailing wage of, say, $50 an hour for the work that they're doing. Well, as you can see, some of the things that are creating problems is misclassification of employers and laborers and mechanics, failure to pay the prevailing wage, failure to pay overtime, and their certified payrolls. Had a situation where on a weekly basis, this particular contractor was supposed to, or ordered to, provide certified payrolls on a weekly basis. The payrolls that he was submitting, he was saying that he was paying the $50 an hour to the employee or to the engineer, but he actually was not. The workers got wind of that, and they reported it to the Department of Labor. The Department of Labor came in and did about a 5-year investigation of this company, collected pay stubs from the employees that showed that they were not being paid the $50 an hour. So that's fraud. So you can imagine, that particular company's leadership went to prison. It's serious business, the DavisBacon Act, but it's a good thing in that it provides a prevailing wage for employees.
Right. And for us, for my company, we deal with a lot on the sheet metal and the iron workers. And to go along with that, it's always important. We got to make sure we pay whatever the prevailing wage rate is for that project. That's typically going to be stated in the contract documents as well as all the fringe benefits that would typically go towards some of the union dues and the other sort of other benefits. That all has to get paid out to each individual employee as well. So to kind of relate back to, I'm not sure if everybody here was in on the estimating first presentation that Eric and I put on last week, but with prevailing wage work for us, when I'm an open shop where not all of our projects are at prevailing wage, but when we're doing any work for government agencies or local city municipalities and whatnot, we just have to make sure we bid accordingly and make sure that our hourly billing rate is correct to cover that cover the prevailing wage rate and all the benefits and everything associated with it.
Boy, it's great to be able to present with someone that gets into the nitty-gritty of some of the theory and the laws that we're talking about. The next slide has to do with the Ohio Department of Transportation, our sponsor. And thank you for the opportunity to do what we're doing and to give people in our audience some exposure, at least on paper in this presentation, to know that, you know, there are opportunities out there for you. And, you know, this slide here just illustrates, you know, the budget and how that budget is being facilitated that will give you an opportunity to gain employment for yourself and for your workers. And you can see what the budget is and how during the pandemic it has decreased by $3 billion from it's not up there, but the previous amount was $7 billion annual budget, but now it's a $4 billion annual budget, and it does create business opportunities. One of the things that I started out with was, you know, the whole contractual relationship and how it relates to bidding with the Ohio Department of Transportation. The invitation to bid is put out by the department, a request for proposals, and that proposal that's submitted is considered an offer for the department in order to accept or reject. Here is a pictorial of what's going on in 2021 in terms of the number of dollars that have been invested so far this year, the number of projects, the effort to preserve the system, 4,596 miles of pavement that have been put down. As a matter of fact, I could hardly get out of my driveway this morning because they're, you know, paving my street. Yay! It needs it.
Yeah, it's funny, as a construction guy, that I can get irritated with road construction, but it's just I live in the suburbs of Cleveland here in Southwest Cleveland, and it's not all the time, but pretty often there's a lot of detours and stuff in our lives these days, and that's a good thing that things are moving forward and things are getting improved. Getting rid of all the potholes and things like that, we really appreciate that.
That's jobs and progress for you.
Yep.
So we have a question from the audience. Someone would like to know, what is the difference between an invitation to bid and a request for proposal?
I don't know technically if there's that much of a difference in terms of functionally. An invitation is, you know, that's my opinion. I think they're pretty much the same. What's your experience?
I would tend to agree with that. Like an invitation to bid and a request for a proposal is essentially the same thing. It's just some entity is requesting pricing and availability and potentially even a scope of work to solve one of their problems. Whether they call it an ITB, invite to bid, or a request for a proposal, they're almost one and the same, and I think they're kind of used interchangeably to the best of my knowledge.
Yeah. We've sort of touched on the Department of Labor earlier in the context of some other things that we've talked about. But basically, it's an enforcement mechanism as well as an assessment and a risk management organization. The situation I was telling you about, the contractor that was underpaying the engineers, well, it was the Department of Labor that came out and conducted that 5-year investigation that brought a very successful case to the federal courts against this contractor. The Family Medical Leave Act, you know, we talked about the poster. We talked about whether or not, you know, an agency, well, I don't know if we talked about it, but what agencies are required to provide FMLA. Those that criteria is established by the Department of Labor, and it's also enforced to make sure that agencies that are required to observe and provide for benefits if a person qualifies for the FMLA are done. They also, as we stated earlier, are responsible for making sure that those posters are in place at places that Garrett talked about. And that's where, employees frequent so that they'll know what their rights are. If a worker is injured, they don't have to necessarily rely exclusively on their company or that contractor to report their case. They can do it themselves. They enforce the minimum wage and the prevailing wage, as we talked about with the DavisBacon. And again, to make sure that the unemployment compensation insurance is in place by the entities that are required to have it.
I just want to add really quickly for the FMLA. For me, this was going back a year and 3 months ago when this wonderful COVID-19 thing started happening, where I had a couple of employees that had to take some time off because at that time we didn't know exactly what we were dealing with, and anybody that had a slight sniffle or a cold or a cough or a sneeze, before you know it, the guys are out for a couple weeks, and we just had to kind of give them additional, almost like an additional 2-week vacation time pursuant to the FMLA and the rules that were kind of changing around a year ago due to the current pandemic.
Yeah, important.
OSHA, I wanted to touch base on from my perspective. A lot of us guys in construction, it's always everybody kind of trembles and is afraid when they hear about OSHA. They're afraid of getting violations because they are the police force, so to speak, for safety protocols and government inspections and making sure that everything is safe and clean and not environmentally harmful in any way when it comes to getting rid of trash and proper disposal techniques and everything like that. From my experience, really, you can kind of reach out to OSHA if you're working on a job site. You can kind of take a more proactive approach to those guys, and they'll gladly come out and give you a unofficial inspection to help you make sure that your project is on the right track. And obviously, if you're proactive about it and invite them out to a job site, they're not going to be looking to fine you because you're being one of their allies as opposed to somebody like an adversarial position. There's nobody to be afraid of. Just make sure you're following the rules. Make sure you guys are tied off and doing taking care of their proper PPE for what they're doing. And honestly, everybody here, any of you guys that have employees, you want your employees to be safe at the end of the day too, and you want everybody to go home the same way they came into work that morning. So it's just another entity out there that is there to help with that as well.
Well, that's really important, and it raises the thought of if you don't take that proactive step, as Jarrett is indicating, you risk the chance, and there's that word again, risk management, of a whistleblower calling the Department of Labor and having them come in unscheduled and perhaps less than friendly visit to cite you and impose fines and could even shut you down. So it's really important that you manage that risk by being proactive. And that's a very, very good point.
It's not a poll question, but I'm just curious, has anybody in the audience had dealings with OSHA inspectors, any surprise visits or any, what has your interaction been like with them? And we can maybe talk about that.
Raise your hand. Yep. Raise your hand, and you want to say that you've had an interaction with OSHA, or if you'd even like to share. Okay, Steve, I'm going to unmute you. You have to unmute yourself if you'd like to share audio.
Okay, I did have OSHA show up on a project after another project had been hit, and they were surprised at how well we recovered. But they are scary people. I gotta admit that. It's almost like you think you're going to go away in handcuffs.
Right. It can be very unnerving if they show up unexpectedly and you're not ready for it. My company kind of practices, if an OSHA surprise inspection comes up, we kind of like slow down on the work side of things, and I have a key person, make sure one of my foremen is the go-to person that goes and talks to that inspector, find out what's going on, make the appropriate phone calls to either me or a project manager that's there and in charge of things, that just to find out exactly what's going on. If there is an unsafe thing, or if they have an issue with something, we want to make sure we find out what that is as quickly as possible, and obviously stop doing whatever practices it is that might have had them come across and what brought them out to the site. I've heard that also, just if they see a construction project go on, they might just stop in just for the sake of stopping in as well. It's not always a gotcha moment. And then there's the other side of the coin where with all the really high-tech cameras that they have, they can be a few job sites away, or it can be around the corner or down the block. And if you've got guys that are not following the proper practices, and if you have guys up on the roof, they're not tied off when they're supposed to be, or something like that, like it might already be too late. So your best option is to just get in front of these guys, have the conversation, see what issues they might see, and make sure you rectify that as quickly as possible.
Hi, Steve. Steve, are you still there?
Yeah, I'm here, Tom.
Okay, good.
You go by Tom or Thomas?
Thomas.
Okay.
Or you can call me Sam. Sam is my first name. Sam. It's good, Steve. What industry are you in?
I'm actually an LPA agency. I've managed contracts. I've actually processed the contracts from the beginning. I've done bid analysis. So I'm kind of like on the other side of the fence from all these other people that you're talking to.
Okay. So we've been talking about contracts and how, during the formation of it, contracts, they can be a really good risk management tool. In your role, you said you manage contracts. How do you respond to that statement that contracts can be a good risk management tool?
Well, actually, the best part of managing the risk is planning. And if you start from the very beginning, you can negate just about everything. I mean, change orders are always something that was not planned. And the question I had earlier about the risk that the contractor takes by not coming to the site and looking at the conditions that he can see, often you can just tell from a bid that a contractor did not show up on the job. He just threw out some numbers there, hoping to get the job, and was going to worry about it when he got there.
Absolutely.
And soft subgrade is something that you don't know unless you have the opportunity to get on the site and dig a test hole. But often you can't do that. But quite obviously, the other things that are obvious are not addressed by people that are doing the bid.
Right.
And that's the biggest risk they take. And planning a little bit better, you can negate that.
Yeah, and when you say negate it, what you're talking about is putting the risk where it belongs.
Correct.
The owner of that particular property that's having you come in to do the work, they should bear the risk of that hazard that you're talking about. And like you said, if you don't come out and observe that habit, then you don't build that into your bid and say that the owner must indemnify you as your client, the contractor, from that risk by obtaining the necessary insurance that if something does happen, that the insurance pays for it and not it comes back on your client as the LPA.
I will add, like, this brings to mind for me just a personal project here that's on the near west side of Cleveland, near the riverbank there. We're putting up a 10,000 square foot facility, a brand new metal building. Ended up adding about 10% to the overall contract. It was roughly $1.1 million project. We had an extra $100,000 in foundations that had to go in and get engineered from the beginning because, as you're talking about the site conditions not being as expected, it's one of those things. The owners purchased the property. They didn't do any of the soil borings beforehand. So when we were ready to move forward with the building project, we tested 4 corners of the building to see what things look like down 50 feet or so, because we figured around the river it's probably going to have some sort of an issue. We just didn't realize how big of an issue it was. Ended up being $100,000 worth of additional footings, concrete, geopier foundations that had to go in to help support a sort of sub footing, so to speak, underneath our standard 42-inch footer. And that's one where every 4 corners of the building was a little bit different. And it seemed like every 10 feet we were hitting slightly different soils conditions. So even when you do as much as you can to try to mitigate that risk and try to do the testing and do all your due diligence, you still run into surprises underground, especially in industrial areas. I'm sure it's the same around any of the other major cities around the state. And then also around riverbanks and things like that, where things have been moved around. And this one is right here near Steelyard Commons here in Southwest Cleveland.
Yeah, that's good. But I like Steve's concept and the use of the word planning. That's critical. But in order for you to plan, you got to have some assessment of what the work site is in order to effectively incorporate that into the contract, and that's good planning. The next area that we have up that we want to just touch upon, because it's a real medicine kind of a concept that has a lot of tentacles to it. But basically, what it is, it's the most effective way in order to collect damages if you are damaged by a contract, whether you are on the owner's side or you are on the contractor side. There are certain things that you must do in order to enforce your rights to damages against someone that breaches a contract. And with that being said, it looks like I jumped the gun, so now we're going to talk about the poll question.
Directly related.
Sorry, I went ahead and put the poll question up.
Thank you.
So, yep. You guys go ahead and vote. Take a second, stand up, stretch too, because I know we've been at this for a while. Getting close to that 70%. All right, we're almost there. Okay, I'm going to go ahead and close the voting down and share the results. 2 answers were selected out of the 4 given. 19% have said okay, and 81% have said no experience with it. So I'll close that final poll question down, and there you go, gentlemen.
Okay, with that being said, that 81%, let me just, in a very general way, just reiterate what I just said. It is an opportunity for either party on either side, whether it's the owner or the contractor, the subcontractor, materialman, or whomever involved in a project, that there are certain things that need to be done, and these things need to be done timely. And if you look at this is just a summary of what I just mentioned, but this is where you get into the teeth of having an enforceable action against someone that might breach a contract. To give you an example, got a contractor, did some work for this owner. The owner has a duty in order to notify the county recorder of the project and where it's located by virtue of, going down and actually filing a notice. Fast forward at the end of the contract, or somewhere in the beginning of in the midst of the contract, the owner did not pay the contractor. So what the contractor did was he completed the task, he did his job, but before the statute of limitations passed on the contractor to file, and we're going to go to the next, a mechanic's lien against that particular homeowner, the timeline elapsed, the 21 days of, after the commencement of the project. So he came to me and said, Sam, I did this and that, and I got paid only a small amount of money, but the project is complete. And I said, well, how long ago was this? And at this point, it was a matter of months. Well, at that point, he was dead in the water. Now, mechanics liens are not the only way of enforcing against a person that breaches, because if that first step is missed by the homeowner or the owner, then all of the other strictures are not adhered to. But just it happened in this case, that homeowner did do that. So I think a lot of people are not aware of the mechanics lien is because it's not necessary if that first step is not taken. Because what you can do is you can go to just common law, if you will, and file a breach of contract against that non-performing homeowner that didn't pay. And at the same time, going back to the illustration I gave earlier about this business owner who had an opening on June the 1st, and the contractor breached against her. Well, she didn't have to rely on the mechanics lien in order to enforce against this person, but unfortunately, she didn't have a contract. So it's going to be pretty hard for her to get a successful action and damages against that contractor. I said pretty hard, not impossible, because there are certain provisions in the law that would give a person the opportunity to receive damages in a situation where there is no contract. Remember I said earlier, for every rule, there is an exception. Now, going back to the situation with the person that needed the job completed by the 1st of June, there are exceptions, and one of them is where a contractor might be paid the $2,000, and there's evidence, that the contractor was paid the $2,000. There's evidence that the contractor came in and did some work but didn't complete it. Well, what a court of law will do is it will evaluate the situation and hold that non-contractual written contract breaching contractor in breach of contract on the basis of that would be unjust enrichment. They have been paid for something that they didn't do. So unjust enrichment is one of the exceptions to some of the strictures that we talked about in terms of a contract. And there are any number of exceptions to the things that we're talking about. We're not trying to write, these things in stone. As Jared was talking about earlier, all of the change orders that take place. It's a very dynamic situation, these contracts. And we would advise you to have somebody like Steve or an attorney or somebody that's skilled and knowledgeable about putting together a contract in order to, again, reduce your risk and put the indemnify yourself.
I just want to add, while we're talking about it a little bit, a few of the things that you mentioned just kind of brought it to mind.
Mm-hmm.
For me, when I start thinking about lien rights, it's not always for the main contractor to an owner. That's also to protect subcontractors.
Yes.
Where you could have situations where an owner pays a general contractor has the work completed by a subcontractor. The subcontractor doesn't get paid for one reason or another, cash flow issues, or you name it.
Right.
And potentially that subcontractor has lien rights on the overall owner and on the property, so that he is sort of insured, so to speak, to make sure that he's going to get, paid up, eventually one way or another. I've also kind of run into it where, to collect checks on a lot of our state projects when we're a subcontractor, we have these lien waiver documents that kind of coincide with receiving checks and receiving payments. So, all the good general contractors out there that are making sure that their subcontractors are paying their, for us, it's usually equipment rental, or I'm trying to think of anybody else that we would subcontract, but we have to sign off on a lien waiver. So I essentially, as me or as my company, take on the responsibility to make sure that my subs are paid with that corresponding check that comes across. It all goes right hand in hand with the conversation, the lien waivers, and how that kind of plays into getting paid and all that stuff. I've had slight issues where a general will kind of withhold payment, or kind of hold making sure you get that lien waiver signed in his hands before you can actually collect the check to collect the payment. So it can be a little bit challenging sometimes, but all in all, it's a matter of everybody trying to protect themselves and to make sure that everybody that's pursuant to the project gets paid at the end of the day.
Mm-hmm. Jared, again, since we have a large number of people not familiar with this, you're talking about the lien waiver. Now, what does, in your experience, what has that done to benefit you, or what benefit is that?
So a lien waiver, from my perspective, is more kind of protecting my customer, so to speak, more than protect myself, because I'm waiving my right to lien the property. When you lien a property, it's essentially, from my outside perspective, you have first rights if that property ever gets sold, or the owner wants to transition the property to another entity or anything like that. If you have a lien on the project, you have first rights to make sure that whatever dollar amount sum that you have been unpaid for, you have the lien for, gets compensated to you before they can sell and make profit on the property to somebody else.
So why would you give up that right? Why would you waive your right to place a lien on that property?
For me, it's because you want to get paid. But to be honest, that's kind of what I look to you for more input on, like what.
Right. Yeah. Yeah, that's something that we'd have to look at the specific of the job, and whether or not you should waive or not, because that's a management decision, and that's a risk that you take. That if you don't waive the lien, then you might lose the business.
Right. And there is the saving grace on the lien waivers is it's always pursuant to the exact dollar amount of the payment coming in. So this is usually when you're getting into the AIA schedule values, monthly pay applications and things like that. So you sign a conditional waiver that's for the specific sum of money, so that it basically states that that check for that portion of the project is going to go to the affected vendors, subcontractors, whether it's my building supplier, equipment supplier, what have you.
What percentage of your business do liens come into play?
I would say most of them, especially if it's anything larger where we're supplying a building or supplying anything major. So it's, I don't know if I could put an exact dollar amount to it, but I would say most projects, anything over like a $10,000, you know, substantial project, we get into, you know, receiving notices of furnishings, and we're supplying notices of furnishing and receiving notices of commencement from the owners or the owner's agents.
That's good. That's good management. As we look through the slides relative to mechanics liens, again, we talk about, you know, the timelines for filing commercial projects, 75 days from the date of work. Don't want to be redundant, but you can read these. And again, if you blow the time requirement within, you possibly waive your right to damages against the person that's breaching the contract. Notice to commencement, we talked about earlier. Affidavit to release of lien, that once the project is complete, the lien holder must release that lien that the project has been satisfied or judged against the lien holder.
I would assume that this, just trying to think of a real life example, is if a subcontractor has a lien on a project because he hasn't gotten paid.
Yes.
If he has at some point down the road gotten paid in full for the project,
yes,
that's where this affidavit for release of lien would come into play. That would be filed by the subcontractor or by the lien holder, whoever filed for the lien.
Yeah, you know, because the damages that can come from that is, yeah, I've got a house and I've got a lien against it, but, you know, I've been adjudged to be not the, you know, the violator of the contract, or I've paid off all the damages or paid for the contract. So this lien must be removed because that puts a negative light on that property if there's a lien.
So is there anything that anybody might want to talk about regarding liens or anything before we jump into ODOT contracts really quickly? And
Question, it just came into the question box. Are there any options for design consultants? If an owner chooses not to pay the design consultant, it doesn't seem like there are any mechanisms like this for us.
If they, well, yeah, you're providing a service. Again, if all of the corrects for the lien have been fulfilled, and you file what you need to file with the county of the furnishings of what you provided, but then you do have a recourse. Now, one of the advantages of taking advantage of the Ohio Mechanics lien is that it might not be as cumbersome or time consuming as your, again, your common law remedies. If you perform a service and you're not paid for it, and you've got a contract for that, then you can always go to the Court of Common Pleas, you know, with a complaint against that, you know, that owner.
I could see, I'm not sure specifically what kind of design consultancy you're due. For me, this kind of brings to mind some of the quote unquote free consulting that we get into on the design build side of things, where we provide preliminary plans for people and things like that. And sometimes, you know, they take your preliminary plans and just take that right to your competition and say, hey, we want to build a building that looks exactly like this. There's not really a whole lot that we've found that we could really protect ourselves from that. But as I've been learning over the past few years, it's one of those things where you want to just stipulate in the contract, or even before you start, you know, undergoing substantial amounts of work on a project, make sure that you have your contract in place, make sure you have your signatures in place. And you could always stipulate upfront funds, or stipulate down payments for some of these projects so that you can protect yourselves from doing free work and not getting paid for it, essentially.
Absolutely. And as we come towards the end of our time together here today, and I say that because we'd like to hear from you when you get back into your shops and you have situations that arise. But it takes us back to the very beginning, and that is the formation of contracts and the elements of a contract. That if those elements are taken care of, you're mutually agreeing to do something. And that mutual agreement is what the court is going to be looking at, whether it's in the context of a mechanics lien, or if it's just, a common law, breach of contract, that you're filing. Like Steve said, planning, and there's no exception to having a contract that anticipates, the risk that you might encounter, and you want to manage it. And one way of managing it is through contracts.
All right, so with that, I just wanted to touch base again with some ODOT specific contracts and documents. A lot of this stuff, really, if you just go to ODOT's website, you can kind of navigate your way through to what kind of entity you are, what kind of projects you guys are looking at, and you're going to have your own specific documents and everything that go along with the projects that you guys might be bidding on. I just kind of wanted to touch base really quickly on the the progress payment form, the change order form, certified payroll form. The essential takeaway from that is you assign the key people, whether it's within your own business entity, and you know who the key people are with the issuing your customer base, to figure out who's responsible for each of these aspects. You want to make sure you know who your accounts payable person is. You want to know who actually authorizes change orders and the dollar amounts associated with that. And it's always important to know who writes the checks and who pays you, so you know who to talk to if things get held up and things get slowed down a little bit, right? So on the website, you guys from ODOT can kind of chime in at any time if you want. I'm sure that systems are always undergoing changes and technology is getting updated, but just from you guys' website, there's an online portal where you can find a lot of these forms if you are contracting and doing work with ODOT or any other government or state agency. And your project managers will be, in my experience, extremely helpful as far as trying to find all of the standard forms that you need to procure to take care of that stuff. I found this. There's actually on the website, there's a change order sort of flow chart, and very recently, or at least as of March, there's a standardized form with predetermined cost codes and predetermined codes for reasons for change orders, like we got into earlier. So every single entity that you guys are doing business with is going to be handling things just a little bit differently. Everybody has their own standardized forms, their own practices, procedures, and ways of dealing with things. So really, you just need to make sure that you have good constant communication with your project managers and with your clients. Even ODOT itself might vary a little bit from district to district. And also like the OTIC, that's the Ohio Turnpike Infrastructure Commission, that's based out of Berea, right around the corner from me. Everybody has kind of their own standardized systems and own way of doing things. For the city of Cleveland, we had a project a year or so back where we had to upload our certified payroll reports to a couple of different online portals to make sure we were in compliance with that. And again, it's just a matter of having the open communication with your clients, and making sure that you actually do read all the book of a contract that some of these entities will issue to you, because there is potentially things like this you have to watch out for, and just an extra line item worth of work that you have to do or have somebody at the office take care of to get all the reports up and running and where they need to be. So kind of with that, we have a few minutes left, so I'd like to really just open it up to see, if anybody has any questions on anything, anybody has anything that they would like to talk about specifically, or even just open-ended. What are you guys dealing with, and what do you guys want to talk about?
Good.
So we have a hand raised. I'm going to unmute you, Steve. Go ahead and unmute yourself.
Okay, it's me again. I just want to say on my end, I was very receptive to this webinar. You guys did a great job. It gives me a lot of insight on the other side of what I can address, in my future. Couple of comments though. The prevailing wage. There's one document missing that I struggle with on just about every contract, and that's the final wage affidavit. Subcontractors will hold up this document because they haven't been paid, and on our end we can't pay it until we have we can't pay the final payment until we have the prevailing wage affidavit.
Right.
To the subcontractors, I'd like to just say that the final wage affidavit is payment to their employees, not to their suppliers. And
Right,
with
in
that
theory,
being
they've already
said,
been paid that, right?
pardon me?
That in theory, at least in my company's case, my guys aren't going to show up unless they've been paid for the previous week. So
Correct.
everybody, that's just a confirmation that you have paid your crew the correct rates for that. It sounds almost like some subcontractors in your situation have been using that the same way that our customer general contractors use the lien waiver, where I've had a lien waiver that I need to sign, and they're kind of withholding payment for us on that side of things. I'm not sure if it's kind of in the same mindset.
You're probably right, but that really puts me into a catch-22 situation.
Yeah.
The lien waivers, that does hold up payment on our end, but we've only been third party to lien waivers. It's usually a subcontractor leaning the prime for payment.
Right.
The other thing I wanted to comment to was the invitation to bid versus the request for proposals. The invitation to bid is for a dollar amount to be bid on a proposal that is put forth by the owner. The request for proposals is a concept put out there by the owner, and they're asking for bidders to submit a proposal with no cash involved. And then we have to go through a quality-based selection process, which is required by law. And it's not based on money at all. It's just based on the best proposal, and then the price is negotiated after the proposal is accepted.
Okay. Yep. From my limited experience on that, it's really, they've been kind of used interchangeably. So that's awesome to know the difference. Now on a ITB or an invite to bid, is that something where like a dollar amount is the difference only in that the dollar amount is included in the proposal, essentially?
Yes. Yes.
Okay.
As a matter of fact, we're a statutory municipality, but even at ODOT, I worked for ODOT for 30 years too, and they, by law, you were supposed to take the lowest and best bid, and it was very hard to describe what best bid was. So you had to take the lowest bid. Now we've kind of defined that a little better, and we actually can take a best bid. That's
good. That helps guys like me out, because I'm as on the metal building side of things, we're a Butler builder and tend to be typically on the higher end of the cost spectrum compared to a lot of X, Y, and Z metal buildings out there. So that we run into that, not all the time, but on a pretty regular basis.
Yeah, Steve, I'm glad you brought out that distinction.
Same back to you, Sam. I'm glad you defined your name versus your last name. I apologize for that.
Not a problem.
Thank you, guys.
Well, thank you, Steve. I appreciate your input, and thanks for joining in and having some conversation.
I just dropped a link in the webinar box from the ODI staff, and it's information on those different types of invitation to bid versus RFP from ODOT's website as a follow-up. Is there anyone else who has a question that'd like to ask, get in the question box, or would like to raise their hand and be unmuted for our presenters today? Going once, twice. Okay, gentlemen. Well, thank you very much. And I know that you have your email addresses up on the screen, so we'll make sure to share those with everyone who was on the webinar today. We hope you found it to be valuable, and we will look forward to having everybody join us again next week for the third and final installment, which will be the accounting module. So we'll see everyone then. Thank you.
Thank you very much.
Thank you for the opportunity.